In the scorching summer, air conditioners, fans, and refrigerators have become essential tools for people to use at home. Now, it is summer, and the fan industry has ushered in a golden period of development in the industry. The fan in China originated from the seven-wheeled fan of the Han Dynasty, with a structure mainly consisting of 7 fan wheels installed on one wheel axle to drive the fan to operate manually. In the Tang and Song dynasties, it relied on water power to drive fans, freeing people's hands. In the Qing dynasty, Emperor Yongzheng created a hand-operated fan with a design similar to that of a modern upright fan. A pull rope was added to the handle of the fan to generate wind power by pulling the pull rope. In 1830, James Barron in the United States was inspired by the structure of clocks and invented the mechanical fan fixed to the ceiling and driven by a spring. In 1872, Joseph of France invented the mechanical fan that relied on a winding turbine to start and was driven by a gear chain device. In 1880, Schuler of the United States invented the world's first fan for electric power generation. In 1882, American technician Hughes Caswhiller invented the commercialized electric fan. In 1908, the United States successfully developed the world's earliest gear-driven electric fan that showcased head left and right. The first electric fan in China was produced in 1916. Mr. Yan Jiquan, the accountant, opened the Huaxing Electric Appliance Manufacturing Factory in Hanban Bridge, Sichuan Road, Shanghai. In 1925, the Huaxing electric fan was officially put into operation, quickly becoming a famous brand and driving a large number of domestic electric fan brands, such as Great Wall, Camel, and Diamond Stone. Nowadays, in order to meet people's increasingly diverse needs, multifunctional electric fans have emerged, such as noiseless fans, time-controlled voice-controlled fans, and all-season fans for both heating and cooling. In addition to the traditional desktop and ceiling fans, there are also tower fans, portable small fans, micro fans, bladeless fan, and other types of fans in the form of fans. The types of fans are more diverse and the appearance is more exquisite. Since the implementation of the patent system in China in 1985, the development trend of fan patent applications in China can be divided into 2 stages: slow growth period before 2008 and rapid growth period since 2008. According to the search, during the slow growth stage, the number of patent applications is relatively small and there are no patent cases. Of course, this does not mean that the fan industry is not infringing. It can only reflect that companies in the market at that time did not attach much importance to independent research and development or had weak R&D innovation capabilities. The development type of fans was relatively single and ordinary, and people's legal awareness was weak, placing more emphasis on the practical functions of fans. In 2008, the fan industry showed a rapid development trend, accounting for the absolute majority of patent applications in the global fan industry, ranking first in the world. At the same time, relevant data shows that the number of foreign patent applications in China has maintained a low level for a long time, accounting for less than 1% of the total application volume. This shows that Chinese enterprises are the main competitors in the fan industry, and Chinese manufacturing occupies the major position in the fan industry. Guangdong, Jiangsu, and Zhejiang, as the main force of patent applications in the domestic fan industry, have gathered multiple famous fan enterprises, such as Midea, Gree, and Nimble Pioneer. With the continuous improvement of people's living standards and the increasingly complex market competition environment, The diversification of fan functions and the aesthetic appearance of products have become the core competitiveness of the industry. Enterprises have gained a deep understanding of the value of patents, and their awareness of rights protection has greatly improved. Some enterprises have gained huge benefits in the process of rights protection. For example, China Amic Technology Co. Ltd. applied for a handheld fan appearance patent in December 2016 and issued an authorization notice in June 2017. Since the patent was granted, Amic Company has been filing lawsuits. By 2020, the number of cases in 1 year had reached over 800, with a total of 1808 litigation documents and 1797 infringement of design patent rights. More than 94% of the cases were filed as plaintiffs and received compensation of 5.374 million yuan. Amic Company's success rate was extremely high. The litigation value of patents has been fully reflected. While safeguarding its rights, Amic Company has not forgotten to continue investing in research and development. It has applied for multiple appearance patents for handheld fans, forming a good cycle between patent acquisition, rights maintenance, and research and development applications. Another example is Dyson Technology Co. Ltd., which is also a model of patent protection in the fan industry. Dyson has applied for patents related to bladeless fan in China as early as 2008. Up to now, Dyson has applied for a total of 1540 patents and will spend 10 to 15% of its sales revenue on R&D every year. It attaches great importance to independent R&D investment. The appearance patent applied by Dyson Company in China not only covers the overall appearance of its products, but also refines the components and supporting software interfaces of the products. The patent application has shifted from overall protection to component protection, adopting a positive strategic layout. Dyson Company has been filing infringement lawsuits since 2012. Suing 12 companies with patent CN 10182-106B fan components and winning the lawsuit, receiving a compensation of 2.385 million yuan. Dyson has applied for hundreds of patents for bladeless fan in China, and this patent alone has brought millions of profits. Based on the comprehensive statistics of the compensation received by the two companies, we can find that there are fewer cases of patent protection for invention, with higher compensation for individual cases. There are more cases of patent protection for design, with fewer benefits for individual cases. The protection benefits of a single stable patent are actually not related to the type of right, but rather to the operation of the protection project. Based on the judgments of China Amic Technology Co. Ltd. and Dyson Technology Co. Ltd., we can obtain the views of the court in the trial of fan cases. Firstly, the judgment of whether it belongs to the same type of product should be based on a comparison of technical solutions, not solely on the name of the accused infringing product. For example, the bladeless fan component not only protects the fan, but also protects the lighting implementation scheme attached to the fan. Whether it has technical characteristics requires considering factors such as the location and materials of the patent involved, and achieving different functional effects of the same material in different locations. Merging the same material into parts cannot be considered as a non-infringing design. For example, the silencing component includes acoustic foam, and the sponges set at the upper and lower layers of the air inlet to achieve different functions of purification and silencing. The sponge integration does not prevent the extraction of a single function to consider whether it falls into the protection scope of the patent involved. The infringement of fan appearance design should be determined based on the parts that can be designed and the overall effect. For example, compared with the traditional electric fan, the bladeless fan is not limited by the blade shape and accommodation space, and its outlet ring, base shape, as well as the connection mode and proportion relationship between them all have large design space. The key point considered by the court is the similarity of these points, for example, the differences in the number of blades, button shape, disc pattern, buckle, base, and other parts of a handheld small fan belong to local subtle differences, and the changes to these parts are not enough to have a substantial impact on the overall visual effect. Notice, the functions of fans are becoming increasingly diverse, and the popular new types of fans such as neck-mounted fans, mist fans, handheld small fans, and fan lights in recent years have brought huge market benefits. The research and development of fan enterprises can be an improvement on mechanical principles or a design of product details. The fan industry involves a wide range of patent types, from utility models, exterior designs to inventions, each with different considerations that enterprises need to pay attention to when selecting and applying. So, how can fan companies determine their research and development direction and how to utilize existing patent advantages? There are several ways to do so. Firstly, enterprises should conduct patent search and analysis on the new fan type. The conditions for granting a patent require the patent to have novelty, practicality, and creativity, which means that the patent application should be distinguished from the existing design. Fans are generally composed of fan blades, shells, motors, switches, and other parts. The emergence of a new type of fan has great inspiration for the market. How can latecomers borrow this inspiration while not falling within the scope of patent protection of others? This requires enterprises to conduct comprehensive patent searches on existing technologies to clarify their research and development direction, and to avoid wasting limited research and development resources in areas that others have already protected. However, patent search cannot be limited to new fans, but should focus on the wide range of fans. Similar products with the same purpose and belonging to the same category can be compared. Although both with and without fan blades have been patented, there are still a large number of technical solutions in the public domain formed by invalid patents. Technological research and development can make good use of public technology. Secondly, enterprises should invest in research and development on the basis of avoiding patent infringement, and explore ways out in terms of appearance, functionality, and drivers. For example, hanging neck fans and the appearance design can be considered in many aspects such as air outlet design, bracket shape design on both sides, neck base design, and headphone shape appearance. When applying, the technical innovation points and protection scope of the patent should be carefully written, while ensuring the stability of the patent. The scope of protection should be expanded as much as possible, in order to bring greater benefits. Finally, legal acts of infringement should be strictly and promptly enforced to prevent others from maliciously seizing their own market while also obtaining additional benefits. Once again, for one's own research and development achievements, it is necessary to apply for patent protection in a timely manner. Shannon Mink Technology Co. Ltd. has gained reputation and profits through extensive rights protection, but the compensation amount brought by Dyson's successful case is relatively small.